Good afternoon. Welcome to the fifth meeting of the Presidential Commission on the Supreme Court of the United States. My name is Dana Fowler, and I'm the designated federal officer for this advisory committee. We would like to thank all of our public attendees and stakeholders for joining us today. Discussion materials that will be the focus of today's meeting are available on our website at whitehouse.gov/PC SCOTUS. Before we begin, a few administrative reminders. This meeting is being recorded via video conference and is also being streamed live on our website at whitehouse.gov/PC SCOTUS. This commission is considered a federal advisory committee and is governed by the requirements under the Federal Advisory Committee Act, or FACA. My role as the designated federal officer is to manage the day-to-day administrative operations of the committee, attend all committee meetings, and ensure the committee operates in compliance with FACA. All of our commissioners have received training regarding FACA requirements and their ethics obligations as special government employees. In addition, each commissioner has completed a financial disclosure report that has been reviewed by ethics attorneys to identify any potential conflicts of interest. I'd now like to turn the meeting over to Commissioner Rodriguez for our next order of business.
Thank you, Ms. Fowler. Before we turn to the work of the day, we do have some administrative business to take care of. We'll be voting on an amendment to the Commission's bylaws. The amendment is posted on our website with the other meeting materials for today, and it replaces the purpose language from the bylaws that we adopted at our May 19th meeting. The edits reflect that our deliberations required more time than the 180 days originally provided in the executive order. So I'm now open to entertain a motion to vote to adopt the bylaws, and we do not require a second for that motion.
I so move.
Thank you, Commissioner Andreas. Ms. Fowler will do the roll call to record the vote.
Thank you. Commissioners, if you would please turn on your cameras, I will call each of you in alphabetical order. Please unmute when you hear your name and vote for the bylaws amendment by saying yay or yes, or against the bylaws amendment by saying nay or no. Your votes will be recorded and captured in today's meeting notes, and this vote will also serve as today's roll call. Michelle Adams.
Yay.
Kate Andreas.
Yay.
Jack Balkin.
Yay.
Bob Bauer.
Yay.
Will Bode.
Yes.
Elise Body.
Yay.
Guy Uriel Charles.
Yes.
Andrew Manuel Crespo.
Yay.
Walter Dellinger. Walter, you may be on mute.
And I vote yes.
Thank you. Justin Driver.
Yes.
Richard Fallon. Commissioner Fallon, you may also be on mute.
Apologies, yes.
Caroline Fredrickson.
Yay.
Heather Gerken.
Yay.
Nancy Gertner.
Yay.
Thank you, Commissioner Gertner. Thomas Griffith.
Yes.
Tara Lee Grove.
Yes.
Bert Huang.
Yes.
Sherilyn Eiffel.
Yes.
Olatunde Johnson.
Yes.
Michael Kang. Commissioner Kang. Thank you. Allison LaCroix.
Yes.
Margaret Lemos.
Yes.
David Levy. Commissioner Levy may be joining us a little bit later. Sorry?
Commissioner Levy will be joining us later.
Okay, we will not record a vote for him. Trevor Morrison.
Yes.
Richard Pildis.
Yes.
Michael Ramsey.
Yes.
Christina Rodriguez.
Yes.
Kermit Roosevelt. Commissioner Roosevelt also had a conflict this afternoon, so no vote will be recorded for him. Virtual Ross,
Yes.
David Strauss. Commissioner Strauss also had a conflict this afternoon. No vote will be recorded for him. Lawrence Tribe,
Yes.
Michael Waldman,
Yes.
Adam White,
Yes.
Keith Whittington. I believe Commissioner Whittington will be joining us in a few minutes. No vote will be recorded for him. Thank you, commissioners. With a unanimous vote of more than 2/3 of our membership, the bylaws amendment is adopted. You may now turn off your cameras, and I have the distinct pleasure of turning the meeting over to our co-chairs, Commissioner Bauer and Commissioner Rodriguez.
Thank you so much, Ms. Fowler. Good afternoon, everybody. Welcome to all of the commissioners who are here and to everyone who is watching. We're gathered this afternoon for our second set of deliberations as a commission. And once again, we'll be discussing a set of very rich and wide-ranging materials that have been revised since our last meeting. And those revisions reflect and incorporate the numerous comments and perspectives that were raised during those deliberations. It's important to underscore that those materials are still under revision and that they do not represent the views of any particular commissioner. And as noted throughout the draft materials, there are numerous points of disagreement among commissioners, just as there is throughout the public debate. Before we begin these deliberations, I want to sincerely and deeply thank our team at the General Services Administration, Dana Fowler, Patrick McConnell, Ivana Henry, and all of the others who have worked so diligently to make sure that we function and function well. They've been outstanding in facilitating our work and our meetings, and we're deeply grateful for their partnership. So I wanted to explain just a little bit about our charge and our process for those who might be engaging for the first time. The executive order that stood up the commission was issued on April 9th, 2021 by President Biden. And that order tasks us with providing him an account of the contemporary public debate over the role of the Supreme Court in our constitutional system. So we're charged with providing an analysis of the principal arguments for and against reforming the court. And throughout the materials, we've considered the legality, efficacy, and potential consequences for our system of government of many of the leading proposals for reform that have been part of the recent public debate over this matter. We've been asked in the executive order to draw from a broad range of views and to assess a broad spectrum of ideas, and we were struck as a bipartisan commission. We've not been charged with making specific recommendations, as commissioners well know, but instead with providing a rigorous appraisal of the arguments and proposals that are animating today's debate, and the materials are written in that spirit. So over the summer, we held 2 days of hearings and heard from 44 witnesses. Their testimony, in addition to a testimony from 23 other experts, is posted on the commission website. To date, we've also received approximately 4,000 unique public comments and 7,000 total comments, many of which were part of organized efforts. These comments have come from members of Congress and public officials. They've come from advocacy organizations, subject matter experts, and members of the general public. Many of these comments address proposals for reform that are considered in the draft materials and that are central to the commission's charge. For example, there are comments that address the question of whether to expand the size of the court and whether to impose term limits on the justices. Many of the comments support these reforms, but many others also support retaining the status quo, and even in some instances, adopting an amendment to the Constitution to fix the status quo. We've also received a number of comments that raise matters that are related in some way to the Supreme Court, which we appreciate receiving and will make part of the commission record, but that are largely outside of our charge as a commission. And we want to note today in particular that the commission has received a series of joint letters from Senators Whitehouse, Hirono, Blumenthal, and Johnson, urging that the commission consider the impact of undisclosed private spending on the confirmation process and the direction of the court's jurisprudence. We have not been charged with directly addressing proposals for reforming the confirmation process or addressing the role of private spending to influence that process in the court, and we therefore have not taken up these questions directly. We do, however, address aspects of these issues in our analysis of reform proposals focused on a judicial ethics code for the court, Moreover, and importantly, we will preserve this and other testimony to this effect in the public record of the commission. So having said that about the public commentary we've received, I want to emphasize that we welcome further public comments and will be receiving them throughout the life of the commission. We will continue to accept public comment until December 15th. However, comment is most helpful to the commission if it is submitted before December 3rd. And as Ms. Fowler suggested, our website regulations.gov is where public comments may be submitted. And the ones that have been received to date are also available for viewing at regulations.gov or on the commission's website. And so with that sense of what we are charged with doing and how we have gone about fulfilling that charge, I want to turn it over to Co-Chair Bauer to talk a little bit about what we'll be doing today in this particular meeting.
Thank you very much, Co-Chair Rodriguez. There will be 5 sessions today to discuss 5 drafts of materials. As you will recall from our last meeting, the commission was divided into 5 groups to research and prepare materials addressing different aspects of the reform debate. And these are for the whole commission's consideration as we collectively prepare a report for the president. Today, we meet for the second time to consider the draft materials which have been edited and developed to account for the deliberations of the commission that took place on October 12th. The materials attempt to set forth the broad range of arguments that have been made in the course of public debate over reform of the court. They were designed to be inclusive in their discussion of arguments to assist the commission in robust, wide-ranging deliberations. Again, they should not be understood to represent the views of any particular commissioner, and as reflected throughout the draft, commissioners have different views, sometimes very different views, of the matters under consideration. Now, we will be discussing issues of great importance to the country and to our system of government at a challenging time for the conduct of public discourse. As a commission, we are committed to deliberating over these matters with respect for disagreement. And we hope and we expect that these deliberations will help us produce a report for the president that fairly represents the full scope of the reform debate, one that informs and advances that debate. And with that, I will turn it back over to my co-chair and Commissioner Rodriguez.
So we're convened today until 5 o'clock, and we will consider the draft materials in 2 different blocks of time. We will first consider the introduction, which sets the stage for the reform debate and provides an account of why the debate over reform is emerging. Chapter 1, which provides a history of efforts to reform the Supreme Court from the very outset of the Republic. And Chapter 2, which addresses the question of whether to expand the size of the court or otherwise reform the structure of the court. In the second half of our deliberations, we will address Chapter 3, which discusses whether to adopt term limits as opposed to a system of life tenure for justices to the Supreme Court. Chapter 4, which discusses ways of potentially reducing the power of the court in relation to the other branches of government, including things such as limiting the court's jurisdiction, changing its voting rules, or giving Congress the power to override decisions of the Supreme Court. And Chapter 5, which discusses a set of issues involving the court's internal operations, including its emergency order docket and judicial ethics and conflicts of interest. We will take a break in between these sessions after our discussion of Chapter 2 at approximately 2:45, and the second half of the deliberations will resume at 3 o'clock. And so now we'll begin with the first session, and I will invite Commissioner Trevor Morrison to provide us with an overview of the introduction to the report. And after he's done the overview, the commissioners who have read the materials and indicated their interest in addressing the topics will provide commentary, and we will move from there to Chapter 1. So, Commissioner Morrison, the floor is yours.
Thank you, Co-Chair Rodriguez, and great thanks to you and Co-Chair Bauer for your leadership of our commission thus far. So the draft materials on the introduction now appear as an introduction. And one difference I wanted to emphasize at the outset from the draft materials that we discussed at our last public meeting is that the long section that had been included here on the history of Supreme Court reform and debates about Supreme Court reform is now its own separate chapter, as Co-Chair Rodriguez just laid out. It appears now as Chapter 1. The work of the draft introduction is to provide an account of the genesis of the current debate over Supreme Court reform, and to outline some of the guiding considerations that the Commission is bringing to bear in evaluating various reform proposals. The materials begin then by talking about the genesis of the reform debate and noting that there is a long history throughout American history of conflict over the Supreme Court, which has often manifested itself in controversies about particular nominations to the Supreme Court. After talking about a few historical examples, the materials then survey 3 recent nominations. First, the vacancy created by the death of Justice Scalia and the nomination to fill that vacancy of Judge Merrick Garland, which did not proceed, and then ultimately the nomination of Justice Gorsuch to fill that seat. Next, the retirement of Justice Kennedy and the nomination and ultimate confirmation of now Justice Kavanaugh to fill that seat. And finally, the death of Justice Ginsburg and the nomination and ultimate confirmation of now Justice Barrett. That the materials discuss that controversies around those nominations and debates and disagreements over those nominations and the confirmation processes that followed provide one significant motivation for the reform debate today. As throughout the materials, the draft here does not propose a single way to understand these controversies. It notes that individual members of the Commission take different views of the processes that led to the confirmations or non-confirmation of the various nominees in those recent episodes, and does not take a particular approach. The draft does not take a particular approach on how to understand those episodes. The draft materials also note that the stakes of the Supreme Court reform debate are as high as they are today, in part because the court is really at the center of escalating partisan conflict generally. And this period of extreme political polarization informs debates over Supreme Court reform. On this point, there is consensus across the Commission. The draft materials suggest that acute polarization, political polarization, is likely to continue to affect the debate over the court's role in our constitutional system and to perpetuate partisan conflict over nominees to the court. From there, the draft materials move to the various proposals for reform. We summarize them, the materials summarize them, and refer to the chapters where each of them will be taken up. That's the outline that Co-Chair Rodriguez provided just now. And then the draft materials provided a discussion of some key themes and principles that might be brought to bear in evaluating various arguments for and against reform. 3 common and interrelated themes are frequently invoked in discussions about reform, and those are legitimacy, judicial independence, and democracy. One significant, I think, change in the draft materials from those that were discussed at our last public meeting is an expansion of the analysis of each of these ideas: legitimacy, judicial independence, and democracy. And the materials make clear that the Commission is not offering single definitions of any of these concepts, but is instead trying to lay out the different ways that these concepts might be deployed for and against various arguments for Supreme Court reform. And with respect to democracy in particular, there's a discussion of different ideas of a democratic check on the Supreme Court itself and what kind of forms those might take. The materials conclude with a short discussion of the value of transparency and its relationship to the work of the court and arguments for and against reform of the court.
Thank you, Commissioner Morrison. At this point, I invite all commissioners to turn their cameras on, and we will begin our deliberations on this chapter. As I mentioned, commissioners have read these materials in advance, and several people have expressed their interest in making an observation about the introduction. So I'll begin with Commissioner Tom Griffith.
Thank you, Commissioner Rodriguez. And I want to thank the members of my working group and especially our chair, Commissioner Trevor Morrison, for the collegial manner in which they've gone about creating our contribution to the report thus far. They've been most accommodating of my suggestions, and They have been serious about their work, and they are committed to upholding and preserving the institution of the Supreme Court. Even so, I'm concerned that the current draft of the report gives short shrift to the remarkable achievements of the Supreme Court and may unintentionally do damage to the institution by assuming too often that judges are mere partisans. Let me illustrate this with a story, if I might. For a decade or so, around the turn of the century, I was involved in the American Bar Association's Rule of Law initiative in the former communist countries of Central and Eastern Europe and Eurasia. I traveled along with others throughout the region and met with courageous reformers who were engaged in the project of building the rule of law in their native lands after decades of totalitarian rule. Many did so under the constant threat of physical danger. It was an inspiring experience to learn from these men and women. Without exception, these reformers hope to create in their own countries what we have in ours, an independent and impartial judiciary. To them, the crown jewel of American democracy was our federal judiciary, and in particular, the Supreme Court. These reformers knew about and cheered Marbury versus Madison, Brown v. Board of Education, the Pentagon Papers case, the Nixon tapes case. In my view, the draft report fails to recognize and highlight what inspired these reformers, the monumental success of the Supreme Court in following and preserving the rule of law. I have no problem with a frank and candid discussion about the proper role of the Supreme Court under the Constitution and cheer those discussions. But that discussion should take place in the context of what an unrivaled success the Supreme Court has been over time. But much of the call for change, including the proposals to expand the number of justices and even to limit their terms, I believe is based on the notion that judges are just politicians in robes. In my 15 years on the DC circuit, serving alongside judges appointed by Democrat and Republican presidents, I never once saw a judge make a decision that was influenced by partisan sympathies. Now, to be sure, I saw honest differences in opinion and how to interpret the Constitution, how to read a statute, or how to make sense of a regulation, but never a difference based on political partisanship. To the extent a judge gives into the temptation to step outside the lane assigned her under the Constitution, our response should be to resist such violations of judicial oath, not encourage them. President Trump famously dismissed a decision he disliked because it was made by what he called, quote, an Obama judge. That cynicism, which breeds distrust in an impartial judiciary, earned an immediate and deserved rebuke by Chief Justice Roberts, who said accurately, "We do not have Obama judges or Trump judges, Bush judges or Clinton judges. What we have is an extraordinary group of dedicated judges doing their level best to do equal right to those appearing before them." I agree with the Chief Justice entirely. It's obvious that our toxic political culture is doing great harm to our democratic institutions. This is a moment when we should be looking for ways to inspire confidence in our democratic constitutions. As now written, I fear that too much of the draft report falls short of doing so. And to that extent, I believe the commission is missing an opportunity to assure the American public that it has good reason to have confidence in the Supreme Court, even if reasonable people can disagree about its decisions. Thank you.
Thank you very much, Commissioner Griffith. We'll next hear from Commissioner Nancy Gertner.
I actually think that I want to pass to reserve my remarks for Chapter 2.
Thank you, Commissioner Gertner. So in that case, Commissioner Burt Huang.
Thank you, Co-Chair Rodriguez. Please let me express my admiration for this excellent introduction to the report. In particular, I can't imagine it was easy to distill the essence of the concepts of legitimacy, judicial independence, democracy, as they relate to the wide-ranging debates about Supreme Court reform. And yet, here it's done elegantly, concisely, with subtlety and precision. And I believe it very usefully sets up the discussions to follow in the report. If I may, my one minor suggestion is about the very last paragraph in the introductory section, which is now a sort of carryover from the earlier discussion materials and now seems a bit out of place given the restructuring. Because this language mirrors the preview of chapter 5 a few pages earlier, my minor suggestion is just to fold it or merge it into that earlier discussion. Again, thank you.
Thank you, Commissioner Huang. We'll next hear from Commissioner Maggie Lemos.
Thanks. And I'll be quick. Like Commissioner Wong, I just want to say thank you to the commissioners who've been working on this introduction. I offered some comments at our last meeting about the conceptual framework set out in this chapter, and specifically about the discussion of judicial independence. And I think the current draft does a great job of clarifying that the concepts that are discussed here and their relationship to court reform can mean different things to different observers, and that the goal of the discussion here isn't to resolve those differences, but to sketch out and distinguish the various perspectives. And on judicial independence in particular, I like the way the current draft flags various questions concerning the extent to which the federal judiciary as a whole may be independent from or dependent on the political branches in ways that may be good or bad from the perspective of a system of checks and balances, and distinguishes those questions from concerns about whether individual judges might feel some pressure or incentive to decide particular cases in particular ways. In my view, some of the reform proposals that the full report will discuss might trigger or might be inspired by the first set of concerns about institutional independence. And some of the analysis, I think, has much more to do with the second set of concerns about decisional independence. And I'm grateful that the introduction now tees up both of those concepts and distinguishes them from one another. So another thank you.
Thank you, Commissioner Lemos. At this point, we can entertain further comments from commissioners who wish to weigh in about the introduction or the comments that have been made. Commissioner Dellinger, it seems like you may want to raise your hand.
I do. Thank you. I would like to second Judge Tom Griffith's remarks. So unlike Commissioner Griffith, I don't believe that the report fairly read undercuts our sense of the importance of the role of the Supreme Court as an independent check, particularly on executive power. But I do understand the importance of that concept. Judge Griffin, I taught Clinton against Jones, the case involving whether a suit against a president should be postponed until the end of his term in office. I taught that at Tsinghua University in Beijing. And the Supreme Court held unanimously. I had argued for the United States the other way in favor of postponement, but the Supreme Court held unanimously in Clinton against Jones in favor of a clerk in state government against the President of the United States. And my students at Tsinghua University in Beijing were stunned and extraordinarily appreciative of the fact that first, that a mere employee could bring the President of the United States into court, but more astounding that she could win. And though I had different views about Clinton against Jones, as a decision, I saw the power of the message that it sent to the world, and what a wondrous thing it seemed to the students in Beijing.
Thank you, Commissioner Dellinger. Are any other commissioners interested in joining the queue at this stage? Commissioner Morrison.
I should have said at the beginning, and so just wanted to take the opportunity here to say how helpful the comments we received, those of us working on these part of the materials, the comments from other members of the commission were since at our last meeting, and that with the benefit of those comments, we were able to make a number of adjustments. I want to thank in particular Commissioner Lemos and Commissioner Fallon for very helpful comments on the concepts of legitimacy and judicial independence in particular. They were very wise and I think made the draft materials much better. I'll also say that I have great appreciation for the concerns that Commissioner Griffith has articulated today and that have been a part of our conversations as the commission has worked on these materials. Like Commissioner Dellinger, I don't read the introduction to embrace the proposition that judges are mere politicians in robes. I think it tries to lay out a variety of understandings, and I hope the materials make clear that there is a very strong point of view that when it comes to thinking about the court's relationship to democracy, for example, it's not obvious what the relationship between the court should be and the preferences of democratic majorities. And there is a strong point of view that the job of judges is to do law and not to do politics. I think that point of view is represented as one point of view held by at least some members of the commission, perhaps a great many members of the commission in the draft materials. That having been said, I share Commissioner Griffith's perspective on the value of the federal judiciary, and of course, great admiration for his service in that branch, and hope that the materials in the introduction anyway, aren't broadly read in the way that he worries they might be.
Thank you, Commissioner Morrison. Are there any other observations to be made at this point? So I quite agree with what has been said, that these materials very effectively take three concepts whose meanings we might take for granted, but make clear that they have a variety of meanings, but those meanings all advance important values, and that they're values we have to take into consideration when thinking about reforming the court. And they're values that require balancing and trade-offs of different interests. And I think one of the things both these materials and the rest of the discussion is likely to underscore is that the court plays a very complicated, multi-layered role in our system of government that can simultaneously do what Commissioner Griffith has underscored, but can also have significant impact on political questions and the development of the political process. So with that, I think now it's time to turn to our discussion of Chapter 1, which, as Commissioner Morrison said, was originally part of the introduction, but now forms its own chapter as historical context for the Supreme Court reform debate. And for an overview of that chapter, I'll turn to Commissioner Allison LaCroix.
Thank you very much, Co-Chair Rodriguez. I'd also like to thank the co-chairs for their leadership of this project, and also my fellow commissioners and others who participated in these discussions, because as you can already tell, I think we've had a lot of rich conversations. I just want to spend a few minutes talking about first the main points of what is now Chapter 1, and then highlighting some of the main changes that have been made since the last set of draft materials, many of which came about because of public deliberation conversations that were had at our last public meeting. So first, main points. What this chapter is doing. I think the main purpose of this chapter is to give the historical background and context in which this debate about potential court reform, but really all debates about Supreme Court reform, have taken place over the history of the Republic. The Supreme Court began operating in February of 1790. That's 231 years ago. And so it's reasonable, I think, to begin a commission report of this scale by asking questions. Why does the court look the way it does today? Which elements are constitutionally required and which are the result of congressional action, institutional change, political factors, and other elements? So this chapter is deliberately, I think, not presented as extra information or a timeline or supplemental, I think precisely because the commission takes as its charge providing a robust historical analysis along with the rest of the analysis that we've been charged with providing to the president. So there are four main themes of this chapter. Those are largely the same as what we saw in the draft materials, again, when this material was in a section of chapter 1 in its previous incarnation. The first theme is the persistence of reform debates. Debates over restructuring or reforming the Supreme Court have been with us since the Constitution was drafted in 1787. So the moment of creation was also the first moment of criticism, and proposals for reform came at that same moment. Debates over the proper role of the court, this section lays out, are not a post-1960s phenomenon or even a post-1937 phenomenon, not even a post-Civil War phenomenon. They indeed go all the way back to the first Congress and the Judiciary Act of 1789. And so the chapter begins there to show Americans in and out of politics struggling with issues about the court's role in a federal republic and in a democracy. But also, I think the chapter highlights changes, the fact that the nature and content of these debates has varied over time. And so it would be a mistake to just look at the past for quote unquote lessons for today without attending to this complex context. So the second theme is the court's dual role. This is a little bit subtle in some ways to capture, but the idea that the Supreme Court is both a branch of the federal government, it plays a role in separation of powers analysis, checks and balances analysis, but also over time, it has come to see itself as, or it has taken on the role for many, as the arbiter overseeing the entire system, determining the meaning of the Constitution. So trying to keep a handle on those two different roles for the court. The third theme, the connection between the court's role and its organization, and the variability in such things as number of seats on the court, which is not fixed by the Constitution, the number of circuits, whether or not the Supreme Court justices ride circuit, meaning hearing cases in the circuit courts, regional representation, all these factors that make up the court's organization and have important consequences for its role in any given moment. And then finally, the relationship between the court and politics. And here we mean politics, I think, in the broadest possible sense, not only partisanship, but a question about how the court is and is not interconnected with political debates and broader political discussions of its moment. So then just a quick overview of some of the newly added material in this draft, the set of draft materials. And the newly added material comes in three main areas. First, criticisms of the court and calls for reform in the context of controversial nominations to the court. Some of this material had been discussed or is still referenced in other chapters, but it seemed useful to put it in this chapter. So here in particular, this chapter talks about the nomination of Justice Louis Brandeis in 1916 by President Woodrow Wilson. Brandeis had been famous for attacking corporate interests, pursuing progressive reforms, and was opposed by many legal and business elites. Also, it must be said, bigotry and anti-Semitism played a role in the resistance to Brandeis. And this is important institutionally also because Brandeis's nomination featured the first ever Senate Judiciary Committee hearing on a nomination to the court. So it's an important moment to understand, again, how we got where we are, but also what might be different about those moments. And Brandeis was eventually confirmed by the Senate. Then we also talk about the nomination of John J. Parker in 1930. He was nominated by President Herbert Hoover, was strongly opposed by civil rights groups led by the NAACP and labor organizations. He was seen as anti-labor based on some of his decisions as a circuit judge, and also widely criticized for many public speeches in which he engaged in outright racist and bigoted language decrying African Americans' participation in politics. The Senate rejected the nomination. So the chapter talks about the context in which that those events also happened and how they were seen at the time. The second additional discussion is a bit more detailed about something the report had already discussed in draft form, Franklin Roosevelt's court packing plan and its consequences. So more political and historical context, the effect on FDR, on the Democratic Party, and on the New Deal, larger institutional consequences, and really trying to demonstrate that there's still significant disagreement among historians and other scholars about what the consequences of the court packing plan and its demise were, again, in these various arenas for FDR's political agenda, for the Democratic Party, and for the larger New Deal reforms. Finally, some additional material at the end of the chapter, talking about the Warren Court as a subject of public debate and a focus of criticism. In this period, in the late 1950s and through most of the 1960s, the Supreme Court was seen by some as too willing to confront social and political issues, and by others as engaging in long overdue protection of civil rights and civil liberties. So there was a movement to impeach the Chief Justice, or a sort of widespread discussion about such a movement, but also proposals to strip federal courts of jurisdiction over reapportionment cases, and movements for constitutional amendments. So another flashpoint historical moment of the court coming in for significant criticism, and also praise for its role in popular and political life. So on that, I'll just say make one final point, which is some commissioners mentioned at the last public meeting, well, should this historical section continue past the Warren Court, or talk about events after 1969? And I think the view that that the draft as it currently stands represents is that, first of all, the historical account has been extended since the last draft to talk about some of these additional debates involving the Warren Court, but also other chapters of the report do in fact discuss more recent debates, including the President Lyndon Johnson's move to elevate Associate Justice Fortas to the position of Chief Justice, which was filibustered by the Senate, or the Senate vote to reject President Reagan's nomination of Judge Robert Bork in 1987. But we can, at some point, of course, history becomes current events. And so it's hard to evaluate as to these historical events, when to sort of include them in history and when to talk about them as the current moment. And also those particular moments, beginnings of the current moment, are themselves debated. So the sense was much of the more recent, say 1970 and onward, discussion comes elsewhere in the report, in perhaps more subject-specific areas. And so at some point, we put a stop or put a period at the history chapter and take up the more recent debates elsewhere in the report. Thank you.
Thank you so much, Commissioner LaCroix. So first we'll hear commentary from Commissioner Lawrence Tribe.
Thank you, Commissioner Rodriguez. I would like to begin where Commissioner LaCroix took the end of her remarks, because I am one of the people who was concerned and remain concerned that the history chapter ends too soon. I do want to say that I think of the 231-year history that the chapter surveys from 1790 to 2021, 75% or so is covered brilliantly. That's parts 1 through 8 of this chapter. But I kept looking for a part 9. I do not think that it is enough to deal with the disputes surrounding, for example, Robert Bork or other nominees, purely in a subject matter context later in the report. So my strong view is that between now and when the report is completed, there be further consideration given to extending the historical treatment. I do think the treatment of the first 75% of the court's history is, as I said, brilliant. It's elaborate. An amazing amount of material is thoughtfully compressed, elegantly and compactly into a relatively short number of pages. And it is true that in its current incarnation, the chapter does a good job of discussing the controversy surrounding the Warren Court's desegregation, reapportionment, establishment clause, criminal procedure, and due process decisions, and addressing the dramatically competing views of those decisions, whether they represented the high point in the court's history or a low point. But it seems to me that a history chapter of that kind is profoundly incomplete unless it addresses the controversy in particular, and this is simply one example, surrounding the Senate's rejection of Robert Bork and its subsequent confirmation of Anthony Kennedy as part of the controversy about the Warren era. It has become common for those who understandably think that Robert Bork was unfairly attacked and who regard the history of his rejection by the Senate as an example of the breakdown of the confirmation process. What is missing from this account is a quite different view of that history, that it was ultimately, despite the overstatements of some of the objections to Mr. Bork, and despite the unfair attacks on him personally, that it was the crown jewel in the history of confirmation. Because unlike subsequent confirmation debates, which involved kabuki theater and ritualized incantations of meaningless platitudes, the Bork confirmation hearing involved a substantive national seminar on whether the Warren era should in fact be deemed as the high point of the court's contributions to human rights and democracy, or as a low point because of the court's so-called activism. In a sense, even though it took place in the late 1980s, the national consensus that emerged about the problems with Robert Bork's judicial philosophy was the first, and in a sense, only national referendum on the question of whether the Warren Court got it right. For many people in that period, the emphatic rejection by the Senate of Robert Bork, which was not a function of the attacks on him personally, but a function of national revulsion at the view of the Constitution that he expressed, a view that treated the Ninth Amendment as an ink blot, a view that treated decisions like Shelley versus Kramer involving racially restrictive covenants as profoundly misguided, a view that said Brown v. Board was probably right, but its companion decision desegregating the schools of the District of Columbia was probably wrong. A view that said the court should not have done what it did in the reapportionment cases. The nation rejected those views substantively, which is why the overwhelming rejection of Robert Bork expressed something of a referendum. Now, in my view, the historical chapter would be much better if it presented both views, not just the one I've just described, but its mirror image of the kinds of controversies that the Bork controversy represented. It is true that at some point, history becomes the present, but I would draw the line somewhat differently and expand the coverage of this otherwise excellent chapter.
Thank you, Commissioner Tribe. We'll hear next from Commissioner Tara Grove.
Thank you, Co-Chair Rodriguez. So the first thing I want to say is the authors of these draft materials did a wonderful job with a truly Herculean task, summarizing well over 200 years of judicial reform in 20 pages. And that is a truly remarkable achievement, and I commend you for it. It's very well written, it's clear, and I think it nicely complements the other chapters. I was particularly impressed with the coverage of the Judiciary Act of 1789 and the surrounding early reform efforts, which I think sets the stage for many of the arguments that you see later in the report. So I thank you for that as well. So initially, I had a similar reaction to Commissioner Tribe that the history needed to go further. And I do think it's a hard judgment as to where one draws the line. I actually had a different part of the history that I wished had been covered, and that's court reform debates that happened in the 1960s, 70s, and 80s over jurisdiction stripping, 80s, 90s, and actually into the 21st century as well. There were many, many efforts to take away federal jurisdiction in reaction to the Warren and Burger Court decisions over school prayer and abortion and desegregation remedies. But ultimately, I concluded that Chapter 4 very nicely covers this part of history. And I think Commissioner LaCroix has an excellent point that one has to stop somewhere, and much of the history can be covered by other parts. So I think Chapter 4, at least for the parts that I felt were not adequately covered in chapter 1. Chapter 4 actually takes up where chapter 1 leaves off in a way that sets it up perfectly. So overall, I just want to say the authors of this chapter did a wonderful job, and thank you so much for all the effort that this undoubtedly took.
Thank you, Commissioner Grove. At this time, I'll open it up to other commissioners who wish to speak to the history of Supreme Court reform. Commissioner Sherilyn Ifill.
Good morning. I too want to compliment the writers of this chapter. I thought it was incredibly well done. I did, however, also have some concerns about the incompleteness of the history. And my concern really stems from the fact that I think that very often in the public debate around what has caused kind of two camps to solidify their positions around the membership of the Supreme Court, that has been laid at the feet of the Bork nomination, and then in subsequent chapters it's discussed the nomination by President Obama of Judge Garland that was not taken up by Senate Majority Leader McConnell, and then Gorsuch, Kavanaugh, and Justice Amy Coney Barrett. And what it leaves out, in my view, is that this has just been an ongoing process of concern and struggle that I think very few Americans and also very few people who comment in this area acknowledge. There has not been a period when this has not been an issue of tremendous controversy. And so I think skipping over, for example, there is a mention in later chapters about the confirmation of Justice Thurgood Marshall, but the fact that he was confirmed, in a vote that was 69-11 and that 20 senators either abstained or voted present is unprecedented, I think, in the confirmation votes of any justice. And skipping over the withdrawn nominations of Carswell and Haynesworth is also an important historical moment and point. And it may actually weave together with the points that Professor Tribe made about a sense of the direction of the court and whether the goals of some in terms of the personnel on the court felt frustrated by the time we even got to the nomination of Justice Bork. So I think just hollowing out that period disserves an understanding of how consistently this issue has been controversial and has been debated and has been wrestled with by people on multiple sides of the divide. And certainly to my mind, how often issues of racial discrimination, segregation, and civil rights decision-making by the Supreme Court has been at the center of the controversy over various justices, their confirmation, and the court's power.
Thank you, Commissioner Ifill. Are there any other commissioners who wish to address these materials or what's been said thus far? Commissioner Ramsey.
Yeah, thanks very much. I'll just be real quick. I wanted to first say that I really like the redraft of the chapter, and I really appreciate the work that's been put into it. I had some comments on this section of the report at the first public meeting, and I appreciate the people who are working on this taking those into account. And I think I want to echo Commissioner Grove in saying that this is really extraordinarily well done, and congratulations to you. I'm not sure what I think about the suggestion that it go forward in history a little bit more. I think that Commissioner Ifill makes some good points about at least a little bit to be said about continuing controversies over nominations. But I'm concerned that taking up a substantial effort to extend this at this point in our deliberations might raise more trouble than it would solve, because I think that it may well be somewhat contentious as to how these descriptions would be done. It would have to be done with great care. And to illustrate that, I wanted to just take a little bit of issue with some of the things that Commissioner Tribe said regarding the Bork nomination. I do absolutely agree with him that the Bork nomination is incredibly instructive and important in the history of the Supreme Court. in the sense of being very substantive, exactly as he said, in terms of illustrating the divide between the ways people think about the role of the Supreme Court. But what I wanted to express some doubt about was that anything in the sense of a consensus came out of that that confirmation. That is simply not the way I see it at all. I think that the views were aired on both sides, and that it was a robust and informative debate that continues to influence us today. But the suggestion that there was anything like a national consensus that came out of that debate, I think is not a fair description of what happened. And indeed, Judge Bork's nomination was rejected, but not overwhelmingly rejected, and indeed rejected largely on party lines. So I think we need to be careful if we were to undertake a substantial extension of this chapter. I think the chapter is so well done at this point that I would be hesitant in adding too much to it at this late date, because it may be very difficult to agree how to describe things that have happened more recently, in which we are perhaps more immediately invested. Thanks.
Thank you, Commissioner Ramsey. Commissioner Eiffel, did you have another comment, or is that from before? Okay, thank you. So are there any further comments? Commissioner Body.
Yes. Hi. I just wanted to say that I think Commissioners Eiffel and Tribe make a very persuasive point about the historical narrative and not ending where it does. I thoroughly appreciate the extremely hard work that was put into this chapter, and there is a lot of thoughtfulness and reflection that was sort of incorporated throughout this whole drafting process. But I do think that because of the concerns that have been expressed, that by ending the chapter where it does, that it influences the narrative and perhaps the public perception of the trajectory of Supreme Court confirmations, that it's more than just sort of a historical data point, that it actually does have a significant, or could have a significant effect on how people sort of read the controversies, the modern controversies about the Supreme Court. And so I just want to add my support for the comments that they both have made.
Thank you, Commissioner Body. We do have time for a final comment if there are any more from the floor. Commissioner Waldman.
I also want to thank those who worked on this, and would only note that if there is further revision to this chapter, bringing the story of controversial nominations closer to the present, that the part of the story, which is that those nomination fights have become increasingly partisan, and that nominations that are not even particularly controversial, nevertheless, only pass on narrow party line votes, shouldn't be undermined by the story of the Bork nomination or any of the other nomination fights from the past, which, while ideological, were not the routine partisanship of today.
Thank you, Commissioner Waldman, and thanks to everyone for your engagement in these first two sets of materials. At this point, I will hand it over to Co-Chair Bob Bauer to introduce the next set of discussion materials.
Thank you, Co-Chair Rodriguez. In this session, we're going to discuss materials and analysis of proposals relating to membership and size of the court. Again, these materials were designed to be inclusive in their discussion of the competing arguments. We will begin with an overview by Commissioner Grove, after which I will recognize commissioners who have indicated an interest in commenting on these topics. And of course, we'll also open it up to any other commissioners who would like to comment either in response to those comments or otherwise. But let me begin, first of all, by turning the overview over to Commissioner Grove. Commissioner Grove, the floor is yours.
Thank you so much, Co-Chair Bauer. And I also want to echo the thanks to Co-Chair Bauer and Co-Chair Rodriguez and Rapporteur and Andreas and Commissioner Andreas for all the amazing work they have done leading this commission. That has been a Herculean task as well. And I think we all do appreciate all of your efforts. So Chapter 2 is about changing the membership and structure of the Supreme Court. So there have been calls to expand the Supreme Court beyond its current size of 9 members by, for example, adding 4 seats. The draft materials here explore the scope of Congress's constitutional power to modify the size of the court and prudential arguments for and against court expansion. The draft materials also discuss several other proposals for restructuring the Supreme Court, which I will describe at the end of my remarks. So just to start with a little bit of constitutional text and history, the Constitution does not say how many judges should be on the Supreme Court. Instead, the Constitution gives Congress considerable discretion to shape the court, and history shows that Congress exercised that power quite a bit throughout the nation's first century. In 1789, the court had 6 members. In subsequent decades, Congress changed the size of the Supreme Court 7 times, setting the court size at between 5 and 10 members. The Supreme Court has consisted of 9 members since 1869, but in 1937, there was a prominent effort to reshape the court, what came to be known as President Franklin Roosevelt's effort to pack the court with up to 6 additional members. President Roosevelt initially claimed that he sought to expand the court with more and younger personnel so that the justices could get their work done. But he soon acknowledged that his court reform plan was, in fact, a response to Supreme Court decisions striking down his New Deal programs. There was some support in Congress for Roosevelt's effort, but the 1937 plan ultimately failed. 2 decades later, in the 1950s, Congress also rejected a proposed constitutional amendment that would have fixed the size of the Supreme Court at 9 members. Now, there was, starting around the mid-20th century, a strong norm against modifying the size of the Supreme Court, but Congress continues to have considerable discretion to determine the court's size. One question today is whether Congress should exercise that power to add seats to the Supreme Court. The draft materials here have been revised considerably in response to comments made at our public meeting on October 15th, and to underscore both the complexity of the arguments for and against court expansion and the depth of disagreement over this issue. I'm going to very briefly touch on some of the arguments. Supporters of court expansion argue in part that the Supreme Court faces a legitimacy crisis because of what they see as a break in the norms of the judicial confirmation process. Supporters argue that court expansion could help restore balance to the court and help address concerning jurisprudential trends made possible by these events. Opponents of the reform, which opponents refer to as court packing, argue that it would significantly diminish the court's independence and legitimacy and launch a cycle of similar reform efforts in the future. Opponents argue that the longstanding norm against modifying the Supreme Court size should be restored. Court expansion is not the only structural reform that has been suggested. I'm going to briefly sketch out other proposals to restructure the Supreme Court, which are described in more detail in the draft materials. One reform aims to ensure more partisan balance on the court. A second proposal calls for a rotation system, that is, a system by which judges would rotate between service on the Supreme Court and the lower federal courts. And a third would create a panel system. That is, the justices would decide some cases in panels of, for example, 3 members. One legal question is whether these rotation or panel systems comport with the constitutional requirement that there be, to quote Article 3, 1 Supreme Court. The draft materials explore the legal and policy questions surrounding these alternative structural reforms. And with that, I will turn the proceedings back to Co-Chair Bauer.
Thank you very much, Commissioner Grove. And I'm now going to recognize commissioners who would like to comment on aspects of this draft, and I'd like to begin with Commissioner Fallon.
Thank you very much, Commissioner Bauer and Commissioner Rodriguez, Commissioner Andreas. You have made service on this commission just absolutely a delight. If anything that carries such a heavy workload could possibly be described as a delight. I also want to thank Commissioner Grove and the people who are responsible for presenting the materials that we're talking about right now. I think that the draft chapter of the report does a really remarkable job of summarizing matters about which people disagree very deeply, and then more than that, conveys the depth of feeling that underlies the agreement. the disagreement. So when I read this chapter, my overall reaction was one of absolute delight that you had done the splendid job that I think that you have. Against that background, I have one relatively trifling suggestion that has everything to do with exposition and really nothing to do with substance. When Commissioner Grove today described the various proposals that the report discusses, she did so with great lucidity. I noted that as I read toward the end of the chapter, toward what was styled as subsection 4 on, quote, other structural reforms, centrally including a discussion of what Commissioner Grove just described as rotation and panel systems. The report is currently drafted, plunges directly into a discussion of the constitutionality of those proposed reforms without describing exactly what the proposed reforms are. An attentive reader can undoubtedly piece together for himself or herself what the proposed reforms are, but I think it would make for a more readable report if those responsible for preparing drafts of this chapter perhaps moved a few sentences or a paragraph of description in the report up ahead of their analysis of the constitutional permissibility of these proposals. Thank you.
Thank you, Commissioner Fallon. I would like to next recognize Commissioner Bode for comments.
Thank you. Thank you very much. I know I was one of the people who had a lot of critical comments about this suggestion at our last public meeting, and I also want to echo the appreciation for the work people have done in trying to find some way to thread the needle between the, this often sort of incompatible criticisms this section has gotten. I know it's not an easy task, and I can't think of anybody who could have done it any better. I guess it has caused me to reflect that it may be an impossible task, unfortunately. And it occurs to me that there's a tension in the way we have decided to approach questions of Supreme Court reform that it's just worth mentioning. There may be nothing at this point that we can do about it. Which is that, one way to think about Supreme Court reform is to think sort of independent of whether the Supreme Court decisions are correct or not correct. Independent of that, those are sort of jurisprudential disagreements. Is there something that, people on both sides of those decisions agree would still help and improve the functioning of the court? And I think the approach in Chapter 3 on term limits and the approach in Chapter 5 on the shadow docket and other procedural questions so tries to take that approach, a sort of decision independent, procedural approach. And there's a long tradition of that kind of procedural reform in the federal courts. A different approach is to not take that, ignore the decisions, to say, no, the job of Supreme Court reform is to make the Supreme Court's decisions better. And so if the Supreme Court decisions are bad or destructive to democracy or what have you, then part of the job of reform is to change the court and cause it to do better things than it's been doing. And it seems to me that approach marks a lot of the debates about court expansion or court packing. That's sort of one of the chief reasons for it, really. And probably also to some extent, the democratization proposals in Chapter 4. And so it just occurs to me that those are two very different ways of thinking about the project. And sometimes there's a lot of frustration and confusion that comes from blurring the two. It seems to me maybe we have to confront them both, and we do confront them both, and maybe this is just the best we can do. But it seems to me that's part of the root cause. I guess the last thing I'd add, which is I hate to mention, is that it's not obvious you'd want the same sets of people giving you advice and decisions about those two kinds of reform. You might ask a very different set of experts with a very different kind of bipartisan character if you want to really put aside the correctness of the Supreme Court's decisions. On the other hand, if you really wanted to focus on changing the Supreme Court's decisions, those people might not be well positioned to give you as much useful information. But given sort of all that and who we are and what our charge is, I appreciate how much has been done to try to resolve that. Thank you.
Thank you very much, Commissioner Bode. Commissioner Pildes.
Thanks, Co-Chair Bauer. I have a problem with a specific point that's made on page 10 of the draft materials. This is a section that's not about court expansion in any immediate or short-term sense. In other words, it doesn't involve the debates in other parts of the chapter about what's called court packing by some people. This is a section that addresses a different idea, which is that over the long run, there might be advantages to having a court composed of 11 or 13 or 15 justices, for example, with each president in a 4-year term being able to add 1 justice until the court reached some larger size, say 13 justices that some proponents might think is a more optimal size for the court. So that's the section I'm talking about. And the draft offers 2 main reasons that some people might support such a change. And it's the second of the reasons that I have a problem with. The draft says there that it might be a benefit to the legal system if the court were to resolve more cases than the 70 or so cases a year it now decides. And that a reason to consider increasing the size of the court to, say, 13 justices is to enable the court to decide more cases. But the reason the court is not deciding more than 70 cases a year right now has nothing to do with the fact that the court has 9 justices. As we know, and the report mentions, in the mid-1980s, the court was regularly deciding 180 cases a year or more, as much as 185 cases a year. The court's shown over many decades it can easily double the number of cases or more that it decides than it currently does. And I actually think the draft could be misleading to readers to the extent that they read it as suggesting that the dramatic decline in the number of cases the court currently decides has anything to do with the fact that the court has 9 justices. And I say that as someone who believes it would benefit the legal system for the court to decide more than 70 cases a year. In the areas of law I know best, the court sometimes gets involved on certain issues only episodically, perhaps once a decade or so. In the meantime, the law in the lower courts can be unclear or confused for many years, even if those issues don't produce the kind of direct square conflict that the court currently requires most of the time for getting involved in issues. So I do think the legal system would benefit from the court providing greater clarity on important issues, even sometimes in the absence of the direct conflict between the lower courts. But there's no factual basis, in my view, for suggesting the court needs to have 13 justices to decide, say, 180 cases a year. Now, that's only one point the draft makes in exploring this particular proposal, that perhaps in the long run, a larger court would be better. But I find that particular point really quite unpersuasive. And I would encourage us to reconsider that particular point.
Thank you, Commissioner Pildes. Commissioner Gertner.
Thank you. I wanted to add my voice to those who have, first of all, praised the overall effort of this, the significance of what we were doing, or at least that I thought what we were doing, and I think this is borne out, is that it was better to have these very fraught discussions in the context of a commission like this, a balanced commission, than as part of the political give and take or on Twitter or in a political campaign. And our discussions have borne that out. In other words, these have been very rich discussions, and I, for one, have changed as a result of them. I came into this process convinced that while there were serious problems with the composition of the court, how that composition happened, what the others have talked about as the legitimacy crisis with the appointment of Kavanaugh, Gorsuch, and Barrett. I believed at the outset that nothing could be done without substantial risk, that the risks outweighed the benefits. I have since changed, and in my comments in the last public meeting, I was concerned that the draft didn't reflect those who believed in expansion, not because of legitimacy, not because even of diversity, but for a much more profound problem, a much more profound structural issue. The draft reflects, at least my view, and I think the views of other commissioners, that this really is a moment unlike any other. unlike any other in which this kind of reform has been debated. The recommendation for expansion is not because of disagreement with particular positions on abortion, on civil rights, etc. It's not expand the court so that the positions I believe in be respected. It's not a position on whether the court has been correct or not in decisions over the past several years. It is about a structural problem, and that's reflected in the draft and a unique moment. One can always assume that there will be changes in the composition of the court in the future. Supreme Court membership will ebb and flow as presidents change. It's not a one-to-one correlation because Supreme Court judges serve life tenure, but the court still changes. The draft reflects our concern that if, at least some commissioners' concern, that if current trends continue, there will not be that kind of ebb and flow in the composition of the court, that the court will be entrenched in ways that have not happened before. And that's why the draft reflects this is a moment unlike any other. As to Judge Griffith's comment, this is not, you can call it partisan. I don't believe that the draft suggests that judges are partisans in robes. Whether one agrees with these positions or not, it is that one judicial philosophy, whether you agree with it or not, is entrenched and will be entrenched even as elections come and go. The draft, I actually think, could say more about why that's the case, which is that legislation to restrict voting for young people, for people of color, gerrymandering to entrench one political party, legislation to put partisans in positions to monitor voting, have been effectively enabled by a series of Supreme Court decisions. The gist of which, again, is that the current membership, the current philosophy, whether you agree with it or not, will be entrenched in ways that it has never before been entrenched. I do think that the draft now reflects what had been Commissioner Eifel's concern, that expansion is also worth considering for a host of other reasons, to strengthen the court as an institution, to reflect diversity, to reflect a changing country, and could enrich the court's decision-making. I continue to object, and maybe this is just words, to the use of this, taking this position and calling it court packing. Court packing was an epithet which was used in Roosevelt's time. We're really talking about, while we're talking about expanding the court, as I said, I think we're talking about something different than expand the court because we don't like where it's going. We're talking about expanding the court because of the court's position on voting rights and legislation restricting voting, and where that's likely to lead in the entrenchment of one philosophy over another. I do want to emphasize, I like the draft because it also talks that expansions need not happen all at once, that there are various proposals to increase one per presidential term or two per presidential term. I think that's a discussion that we ought to have. And finally, I think although the draft says this, I would actually like to flesh it out more. I understand the risks. The commissioners talked about the risks of proposing expansion, but I think that we need to flesh out more about the way the need outweighs those risks, that risks associated with expanding the court really don't compare in severity to the risk associated with failing to take action. Thank you.
Thank you, Commissioner Gertner. And now I'd like to recognize Commissioner White.
Thank you. Thank you very much to the chairs and to all my colleagues here on the commission. Those who read the new draft of Chapter 2 will find that it differs significantly from the draft materials that were released weeks ago. They're very different. The new draft now sets apart the arguments in favor of court expansion and the arguments against court expansion. The structure, I think, of this draft is understandable given the diversity of views on this commission. But I do think that when you read the two sort of separate sections of the pro and con arguments, they really are two ships passing in the night. Each side is presenting its own affirmative arguments without really responding to the other side's arguments. And again, I think that's understandable, but I think that each side's criticisms of the other side are often left implicit rather than explicit. Now, I can still support, I think, this draft, because I do think it does accurately describe the arguments that the critics of court packing have put forward, and also the arguments for the proponents of court expansion, the arguments they've put forward. I think these are accurate representations of what both sides are saying, and we're reporting it accurately to the president. I do fundamentally disagree with the arguments made in favor of court expansion in practically every respect. I disagree with the advocates' view of history, the history of the court and recent history of the Senate, and the suggestion that anything in recent history would justify breaking with the now longstanding norm against tactical court expansion. I disagree with the advocates' view of the present state of the Supreme Court, its approach to the rule of law, and the suggestion that that would justify tactical court expansion. And finally, and maybe most emphatically, I really do disagree with the advocates' view of the future, the suggestion that they can narrowly tailor an argument in favor of court expansion that wouldn't be used not just to pack the court now, but by other advocates in the future. I just don't think we can gerrymander an argument for court expansion in that way, and I think it's dangerous to try. Just one last note. We as a commission have now studied this issue for months, and many of us, surely all of us, have been thinking about it for months and years before we joined this commission. It's understandable that at the end of this process, we will not make collective recommendations one way or another. Again, that's not really our mandate. And even if it were, a commission with this diversity of views surely couldn't come to agreement on that. So collectively, we won't offer recommendations. Individually, I do think when this process ends, each of us, all 34 of us, really do owe it to ourselves, to one another, and to the public to be very clear and forthright in our views of the actual merits of court expansion in general and in this specific moment in time. I hope that President Biden calls upon us individually to give our candid and honest views of the merits of these claims. I hope that Congress calls upon each of us to offer our views, and I hope the public calls upon each of us to offer our views. We as a commission have been entrusted with great resources and great responsibility to take these issues seriously. And I really do hope that the submission of a final report is not the end of a conversation, but the beginning of a conversation. Commissioner Gertner, she and I, needless to say, based on our last comments, we disagree profoundly with one another. We do respect one another, and I'm grateful we've had the chance to serve on this together. For all of our disagreements, I do agree with something she just said, where she said we're at a unique moment. I agree that it's a very unique moment. I think it's a uniquely dangerous moment, though, to expand the court. And I'll end my comments there. Thank you.
Thank you very much, Commissioner White. And I would like now to open it up to any further comments, either on these comments or on any other aspects of this draft that a commissioner would like to address. Commissioner Grove.
So thank you to everyone for these terrific comments. Always very helpful, as were the comments at our last public meeting. Just a couple of things I want to say. I think that as this discussion shows, there is profound disagreement on the subject matter of this chapter. I think perhaps more profound than on any other part of the report and that of the draft materials and what this commission is trying to do. But I also think it's extremely valuable that we've had this discussion. In our society today, many people who fundamentally disagree on issues simply do not discuss them. And not only have we discussed them and fought over them in some cases, strongly debated, but we have done so while maintaining respect for one another and respect for the fact that we do fundamentally disagree. And so while I think this is a challenging task, I don't think it's an impossible task. I think it's something that we can and have come together on, even if all of us have parts of this chapter and other parts of the draft materials that we would actually prefer to change. On the specific comments of Commissioners Fallon and Pildes, thank you very much. Commissioner Pildes, I think we need to think about your suggestion. And Commissioner Fallon, that's absolutely right. We can clarify the discussion of the other structural reforms. And I thank you for making that suggestion.
Thank you very much, Commissioner Grove. And I certainly want to associate myself with the view that this is a time when a commission like this, with its diverse views and backgrounds, can come together to have a meaningful conversation without in any way, as Commissioner White pointed out, overlooking the fact that there are significant individual agreements. Any individual commissioner might well have written the report differently, but we had a charge to provide a fair account of the competing arguments and a critical appraisal of the reform proposals. And I think that this commission has admirably joined collectively in the effort to do that. And I do think it's an important time to show that that can be done. So thank you for those comments. And I'd like now to recognize Commissioner Rodriguez.
I wanted to make a comment that in a sense follows from what Commissioner Bode said at the outset, which is that I think one of the ways in which this chapter succeeds, and this is true of other parts of the report that we'll talk about later as well, is that it makes clear what the stakes of this debate are. And we're not charged with making recommendations or coming down on one side or the other of this debate, but I think this does an effective job of laying out the worldview that is behind the arguments in favor of expansion and the arguments against expansion. And those worldviews consist both of predictive judgments that may or may not be correct, as well as of values, some of which are in common, but which people think are affected differently by those empirical questions that are guiding their sense of whether to take the step of expanding the court or not at this time. And for that reason, it falls into the kind of category that Commissioner Bode described at the beginning, which is that these are debates about a set of political controversies and maybe even legal controversies that we're having today, but are not about the institution of the Supreme Court writ large per se, in the way some of the other chapters are. And I hope that what this will do is, both by rigorously describing the worldviews and the arguments made on both sides of the debate, enable people who have the power to either do something or not about the structure of the Supreme Court to make good decisions, and good decisions that are informed by a certain amount of epistemic humility, which I think this chapter ultimately, by taking the approach that it does, reflects, even if that was not its ultimate intention or its initial intention.
Thank you, Commissioner Rodriguez. Commissioner Eiffel.
Very brief point. First of all, I think the chapter does really an excellent job of laying out the different arguments. And I guess I have always been less ambitious than some about this process. What I hoped would happen is that the arguments and the best arguments and the support for those arguments on all sides of this issue would be lifted and raised and available for people to educate themselves and to provide the underpinning for what is going to be an ongoing conversation. So I feel really rather satisfied. I do, however, agree with Judge Gertner that something that stuck with me is the repeated use of the word court packing. And this is, in fact, I think, something of a drafting issue that and consistency issue that will have to be worked through. In Chapter 5, there was serious pushback against the repeated use of the word shadow docket, and it was actually eliminated in many sections and now almost entirely reads as emergency orders. So if we're going to do that there, I think you should reconsider the use of court packing, except when you're talking about how it was used in a historical period, in the Roosevelt period, where court packing was the colloquial term. But if we as commissioners are not going to use the colloquial terms for some of these changes, then that should be consistent throughout the document, and court expansion would be more appropriate in this chapter. It's in the headings, but in the text, court packing is used quite a bit.
Thank you, Commissioner Eiffel. Commissioner Tribe.
Thank you, Co-Chair Bauer. I want to associate myself with Adam White and with Cheryl and Eiffel and others who have said that the process itself has been illuminating and educational, and at a moment in our history when people find it extraordinarily difficult to talk to one another sanely, let alone rationally, about matters on which they differ deeply in terms of values and about epistemic differences and differences in prognostication, it is, I think, a very good sign that we have been able to do what we've been able to do. But I want to add a word to that. If one were being simply hard-headedly political, one I think would likely say that no matter how elegant, exquisite, thoughtful, careful, informative this report is, the likelihood of political movement in response to any of its appraisals, positive or negative, is not high. The nation's agenda is filled with pressing matters, and the likelihood that anyone will take up the cudgels in favor of any significant change in the Supreme Court, even if that group or individual is persuaded by the arguments in favor of change, that likelihood is not great. But that does not lead me to think that this extraordinarily time-consuming enterprise has been in any way wasted. As a teacher, as someone who has spent 50 years thinking and teaching about these matters, I focus not only, and I'm sure this is true of all of us, I focus not only on the likely short-term impact of what we produce and present to the president and to the public, but I focus on what things will look like when my grandchildren are in positions of influence and power, when my students have assumed positions of influence. And for a moment, I want to disagree a little bit with those who say that we are on a completely one-way ratchet and that the world will never change. With Commissioner Gertner, I fear that that may be the case, but I strongly hope that it is not. That those of us who think that we are in a moment in which if we don't do anything quite drastic, we will go off the edge in terms of the American experiment. I hope that those of us who fear that are wrong, that 20 years from now, 50 years from now, debates about the role of the court, its importance in preserving the rule of law, in preserving the values that Judge Griffith mentioned, its importance will still be with us. And the question of where its direction ought to go will remain. And the debates about structural reform will again arise. And when that happens, I think it will be the case that nothing else out there, and I think we've all looked very hard, nothing else out there comes close to what this report will do in laying out calmly and thoughtfully the arguments for and against various changes, many of which on the surface seem a lot easier than it turns out they would be. So looking into that more distant future, I'm incredibly encouraged about what we have contributed, and I believe it has been worth the effort.
Thank you very much for that, Commissioner Tribe. Commissioner Griffith.
So I want to agree with Commissioner Gertner about the gravity of the moment that we find ourselves in. We probably think we're in a grave moment for different reasons, but I do think this is a grave moment in the nation, and for that reason, I'm perhaps more optimistic than she is. I'm certain I am about the present state of the Supreme Court and the role that I hope it will play to get us through the difficult times we're in right now. And so my statement at the outset was informed in part by my concern that if we aren't careful and if we reduce the stature of the court in the eyes of the American public, that it may limit its ability to get us through the I think very difficult times we are facing and we yet face. I associate myself completely with Commissioner White's comments and wish I had said them as well as he had. And finally, with Commissioner Bode as well, but my biggest concern about this commission, and I agree with the comments that it made about what a wonderful exercise it's been in having thoughtful people with deeply held views speak with one another civilly and learn things from one another and actually be willing to change views from one another. I think it's been a wonderful exercise in that way. I do have a fundamental concern that the premise a premise of the, many of the proposals for change is that change is necessary. And as a Burkean, I worry about change, right? And I worry about unintended consequences of change. So my concern about change is I think we have something really precious and good and in the Supreme Court that's been created over the years with difficulty. And I just worry about changes being made that having unintended consequences that will limit its ability to play a critical role in the difficult times that I fear are upon us and will continue with us for some while.
Thank you very much, Commissioner Griffith. Do we have any additional comments from other commissioners at this time? Well, thank you very much. That was an excellent discussion. We will take a break now until 3 p.m., at which time Commissioner Andreas will moderate a discussion on the length of service and turnover on the court. And we look forward to seeing you there at 3 p.m. We'll resume. Thank you very much.
Welcome back, everybody. In this session, we will discuss the materials regarding the length of service and the turnover of justices on the court, also known as term limits. As with the previous chapters, these materials aim to be inclusive in their discussion of the arguments for and against reform. We will first hear a brief summary of the contents of the set of materials from Commissioner Rick Pildes. I will then call on the commissioners who, after reviewing the materials in advance of this meeting, indicated an interest in speaking to the topics, and then we'll open up for any other commissioners who wish to speak. So for now, I will turn it over to Commissioner Pildes. Thank you.
Thanks very much, Kate. And I want to start by thanking our co-chairs, Bob Bauer and Christina Rodriguez. And I know that sounds obligatory, but they've really done a masterful job of steering the ship, and we will hopefully reach port safely soon. And I want to acknowledge also the goodwill and the efforts of my fellow commissioners, particularly those I've worked most closely with over the course of our discussions. I'll summarize the discussion regarding proposals that the country should consider changing the current system of life tenure for Supreme Court justices to a system in which the justices would serve for a fixed term of a specific number of years. And the draft refers to this as a system of term limits for Supreme Court justices. And it's one of the proposals that's been central in discussion of possible Supreme Court reforms going back at least the last 20 years or so. The main term limits proposal the materials address is one in which the justices would be appointed to terms of office that would last for 18 years. Under this proposal, that would mean that each president in a 4-year term would have the opportunity to nominate 2 justices to the court. Most proposals suggest that the president's first nomination should arise in year 1 of the new presidential term and the second in year 3 to avoid nominations arising during election years. As we noted in our first public meeting, term limits for the court is a proposal that has drawn considerable bipartisan support over the years. The commission heard testimony from a large group of experienced Supreme Court practitioners, including former Solicitor Generals appointed by presidents of both parties, who concluded that the proposal warrants serious consideration, in their words. Both originalist and non-originalist constitutional scholars have endorsed term limits for the court over the years. And as Judge Griffin alluded to in his testimony or his comments earlier today, the single feature of the American Constitution that has been most widely adopted in other democracies is the idea of a written constitution and the system of judicial review. Yet the materials also note the US is the only major democracy in the world that has neither a retirement age nor a fixed term for its highest court judges. To be sure, there's significant concerns that need to be confronted in considering the proposal for term limits. And the major change in these materials from the prior public meeting, in light of the comments made then and discussions since, is to develop in much greater detail the reasons that those who oppose term limits believe they would be a bad idea. Let me first quickly highlight some of the main justifications proponents of term limits offer. First, term limits would regularize the appointments process and make appointments more predictable. The Constitution created the process of presidential nomination and Senate confirmation, but proponents of term limits note it's difficult to see the justification for the number of nominations any president has the opportunity to make to vary greatly based on random chance, such as when justices happen to leave the bench, whether through illness, retirement, or death. Some presidents end up with the opportunity to fill several seats on the court during a 4-year term. Others end up with no vacancies during their 4 years as president. In addition, the current system creates a risk, proponents point out, that some members of the public will perceive the justices to be retiring or failing to retire for what the materials call strategic reasons. That is, the justices choose when to retire based on whether they prefer a particular president to fill their seat. And whether this occurs or not, the perception that it occurs can undermine public confidence in the court. By regularizing appointments, a system of term limits would make the process, in the view of supporters of this proposal, appear more fair, less arbitrary, and more predictable. Since all justices would serve 18 years and only 18 years, term limits would also remove the incentive that currently exists for presidents to consider only relatively young nominees who have the potential to serve for many, many decades. And as I mentioned, the draft gives much greater voice to the concerns that have been raised by those who are troubled by the prospect of term limits. One concern that's been raised is whether a system of term limits would compromise the extremely important value of judicial independence. Another major concern that's been raised is whether the prospect of each new president having 2 nominations for the court would make the court even more of an issue in electoral politics, and how that might affect public perceptions of the court. In our prior hearing, some commissioners also raised concerns that giving presidents 2 nominations every 4 years would give presidents too much power to shape the court. And the materials now give greater voice to that concern as well as others. And I'm sure in the discussion, we'll hear more detail about those concerns, along with greater elaboration of the reasons proponents believe a shift to 18-year terms for justices of the court would be better for the court and for the country. Thanks.
Thank you, Commissioner Pildes. So we will turn now to those who express an interest in participating in advance and then open up for additional comments. Commissioner Ramsey.
Well, thank you very much. And first of all, I wanted to congratulate the people who worked most directly on this new draft that we have, because I think this is really an outstanding presentation of this difficult issue. I was one of the people who was somewhat critical of the earlier draft that we saw, and I think this one is extraordinarily much improved, and it presents a very balanced discussion and very useful discussion of the issues that term limits bring up. So a great job, and it's a pleasure to see this the way that we've been able to work together to produce this product. So I wanted to raise one fairly small thing, actually, although it's an important thing to me, but it in the larger scheme of this chapter, it's actually, I think, a fairly small one. And I want to apologize for not having raised this before. It was actually something that was in the previous draft, but it didn't catch my eye the first time around, because I think I was focused more on the front part of the draft instead of the back part. So this is in the back part. It has to do with the first paragraph on page 26, which is in the section that is talking about difficulties of implementation of a term limits proposal, and in particular the question of whether something need to be done in the confirmation process to make sure that the process doesn't break down by the obstruction of the Senate of particular nominees. And so I think that discussion is a good one and an appropriate one. I just had trouble with this one paragraph, which is sort of at the end, and it struck me as almost as an afterthought, that the draft says, and a quote, a statute might provide that if the Senate fails to confirm one or both of the president's scheduled appointments, the next president of a different party would lose a corresponding number of appointments. The draft then goes on in the next sentence to say, without any analysis, this proposal does seem constitutional, although it raises some practical concerns about the proposal. I actually have grave doubts that such a proposal would be constitutional, depending on how it was structured. The Constitution gives the president, with the advice and consent of the Senate, the power of nomination and appointment. I'm not sure how a statute could purport to remove that power from the president and the Senate, even if it's in the worthy goal of trying to deter a breakdown in the confirmation process. At an absolute minimum, it seems to me that substantial constitutional analysis would be needed in order to reach to the conclusion that the proposal seems constitutional. And I think that significant weight would need to be given to opposing views, at least unless I could be persuaded that it is in fact clearly constitutional. But I think that there could be a lot more to be said here, and a lot more needs to be said were we to reach the conclusion that such a proposal is constitutional. But I actually have an easier solution, which is I don't think we need to address this proposal. I don't believe that this is a proposal that was brought to before us by any of our witnesses, and I'm not aware that it is a proposal that's been widely discussed or even not widely discussed in the public commentary about term limits. Maybe I just missed it, and I apologize if I did. But I don't think that we're obligated to raise and consider in any and all proposals that might be out there. And I think, moreover, that there are some serious practical difficulties with this proposal, which the draft currently notes. And it seems to me that for various political reasons, it's likely to be, in any event, a non-starter. So because of the complex, as I see it, constitutional issues involved with such a proposal that I think wouldn't be useful to get into, I suggest that we simply delete this paragraph because I think it is it's not really a proposal that stands much chance of being adopted, and it's not one that makes exists as a significant part of the public debate on term limits. So I think it would be much simpler just to take the paragraph out rather than get into the significant constitutional analysis that we'd need to, I think, to support any kind of conclusion that such a statute taking away the president's power of appointment would be constitutional. Thanks a lot. That's all I got.
Thank you, Commissioner Ramsey. Commissioner Levy.
Thank you very much. And I particularly thank Rick Pildes for his excellent work and for working with me on this chapter. And I thank all of the other commissioners and our leadership. The chapter does, in my view, a very good job of presenting the arguments for and against term limits, and in what may be its most significant contribution, exploring some of the considerable complexities and multiple difficult decisions that would arise if term limits were to be implemented. Anyone who has not thought deeply about the subject will find the chapter illuminating and may find, as in my case, that having read the chapter and on further reflection, they are opposed to term limit proposals. I suggest a very few places where modest revisions may be in order, and I do so in the spirit of strengthening or clarifying the report and with great respect for my colleagues on the commission. First, I think it's important that the commission disclaim support for either side of this debate, perhaps using language that is similar to the language used in Chapter 2. The impression is somehow given that this has widespread support and perhaps therefore widespread support within the commission. I don't know if that's true or not true, but since we are not making recommendations, we ought to be clear that we are not taking sides on this debate, but presenting the debate. Second, there's some places where the text seems to me to slip into what I would call the voice of the commission when discussing arguments and points of controversy, and I think we should be permitted to do some further editing in those places. Third, reliance on state Supreme Court analogs. This needs clarification and qualification. There are no non-renewable term limits in the state system for Supreme Court justices. In the state systems, justices hold renewable terms. Generally, I believe it's true, without limit, that is, they can be renewed any number of times, and they involve some kind of election process on renewal, whether it's a partisan or retention election, or they go through a reappointment process in the political branches of the state government. So I don't think we can point to the state courts as a model of term limits that should be persuasive in this context. And I look forward to further developing that point. Rick and I have had some discussion of this, and I think we can do that. Fourth, I'd like to give somewhat further, very brief consideration in the opposition section to statements by proponents of term limits to the effect that justices become out of step with the times by virtue of their life tenure. I realize that most of the people on this commission, most of the members of this commission are experts on life tenure because they have life tenure. And so perhaps they can enlighten me on this topic and the possible connection between tenure and what I'll call ossification. Perhaps it's okay to be amusing from time to time. This is another point, addressing the 12-year limit proposal, which appears later in the chapter and is presented now as a plausible alternative to 18-year terms. The central issue here is that a two-term president will have appointed a majority of the court before concluding the second term. And I don't think the draft does enough to identify the obvious danger of presidential control, overreach, control of the court under such a system. I'd like to see more on that. Or perhaps the 12-year term could be eliminated, that discussion. Sixth, there is a wrap-up or summary at the end of the opposition section after 3 dots, which in my view, erroneously now characterizes the opposition to term limits as mostly based on a fear of unintended consequences from any reform of a significant part of Article 3. That's a concern and should be said, but the consequences we are likely to experience are at least enough for this particular opponent, and this is easy to revise and does not introduce any new arguments. Seventh, I think we should retain the ability to do some limited general editing designed to clarify existing points and remove repetition. And I'd also suggest that just in the spirit of consistency with other sections, that we remove some of the counter arguments from the opposition section, since we don't present counter arguments during the presentation of the 4 arguments. Eighth, there seems to be a suggestion that by providing for nomination and confirmation by the political branches, the Constitution implicitly provides for an equal number of appointments by the president and the president's party during each presidential term. I'd like to see this point challenged in the opposition section. Ninth, I think we should give greater salience to some of the negatives in forbidding a justice from leaving the court and taking other employment. This prohibition on further employment is a key part of the term limit proposal, but it could trap a justice in place who is unsuited to the job, and there have been such justices, who dislikes the work or who is no longer up to it. That can't be good for the system. There also may be justices who, because of illness in their families or for other reasons, need greater income and would find themselves forced to resign and yet be unable to do so and seek other work. 10th, as part of the opposition case, I would like to consider the extent to which the term limit proposals for the Supreme Court might open the door to extending the proposal at some later time to the entire federal Article 3 judiciary. I see this as a negative, but I suppose that others may see it differently. 11th, and finally, I wish to reserve the ability for myself and other commissioners to review this chapter and in fact the entire report before we vote on it, and to assure ourselves that the report does not give the impression to the American people that the commission as a whole views the Supreme Court or the Article 3 judiciary either as the spoils of political office or as participants in partisan politics. Judges are not politicians in robes. They swear an oath to do equal justice. And in my experience, based on nearly 17 years as a federal judge, so not the full 18, but 17, that is exactly what they do and what they aspire to do, sometimes in enormously difficult circumstances. To the extent that there may be language in any part of the report that may give a different impression on behalf of the commission, I think we must retain the ability to correct it. Thank you very much. Appreciate it.
Thank you. Commissioner Balkin.
Thank you very much. I welcome the comments by Commissioner Levy, which are very sound, and I think it won't be difficult to accommodate them in the draft, since they are, I think, rather minor. But it did give me an idea. One of these criticisms gave me an idea because he was pointing out two things about tenure. One, he was pointing out about tenure about academics. And the second thing he was pointing out was, well, what about life tenure for federal judges? And as I thought about it, so here I have to thank you, Commissioner Levy. It struck me that rotation matters more where there are a relatively small number of people who hold a position. So 9, as opposed to many thousands, and even larger if we think about tenured faculty. Where you have a very, very large number of people who have life tenure, just the flow of generations, people retiring, will in fact take care of many of the problems that give rise to the need for term limits. And that's why it's somewhat less urgent to have term limits for all Article 3 judges, just because a huge number of them are appointed in each presidential term. And so what you get are many of the benefits of rotation that come that way. On the other hand, if you decide, as the United States does, to have one Supreme Court, and that is the language, which consists only of 9 people, then in fact, reliance simply upon generational turnover is less likely to give you the benefits of rotation. And so in fact, comparing the Supreme Court, 9 people who hold their jobs for life and have enormous amount of power, I should say, to much larger populations actually suggests a very good reason to have term limits for that court alone. And thank you very much, Commissioner Levy. I think we should include that point now in the draft.
Thank you. Commissioner Johnson.
So I just wanted to say a few things. One, I think that the chapter strikes a really nice balance of presenting the debate in all of its complexity, so much so that some could read this and think it leads to nothing, right? It sort of presents thoroughly arguments on what one might call both sides, and I think it does so exhaustively. But I think in addition, it really does spend a lot of time thinking about questions of design that are really difficult, not just the constitutional statutory line, but also the question of how whatever route you pursue could create some sort of unintended consequences. And that took a lot of work and creativity and just care. And I just, want to thank all who had input in it and all the commissioners on that. On the question of state courts, I read this current draft to be careful about what it's saying about state courts, just to point out that they do have, most of them, renewable by election terms, but most of them also have mandatory retirement ages. I didn't read the draft to really suggest that the federal courts could be compared to the state courts in all dimensions, because of course they can't. State courts have all sorts of differences. Their constitutions are different, and in a lot of cases, much easier to amend. And they are different in ways that I think matter for drawing comparisons, but I thought they were just a data point and a useful one in addition to the comparison perspective. And then the last thing I want to say is I think we sometimes struggle, and maybe this goes to the last sort of point about how do you create a tone that both acknowledges that there are political stakes to appointments. That's why there has been so much wrangling over them. Okay, so some of the concerns that lead some people to term limits would exist even outside of and apart from a confirmation process that is fraught. But the role of fighting over confirmation, aggressive political tactics, strategic retirements is pushing some people to the position of term limits. And I think the report is really careful to talk about that real phenomenon without then falling into the trap of saying judges are all mere partisans. I think it holds both things in its framework. And I think we have to be able to. The reason that there are stakes in all of this is because people think that there is a difference and an implication for the court in who is appointed. And I don't think it would be good to be utterly naive about that and not mention that. But I don't read anything in the report to suggest that means that ideology and partisanship are perfectly coextensive, or that judges are just driven by partisan motivations. And if it does, I'd love to be, to know where the language could change a little bit to satisfy those who have that concern.
Thank you, Commissioner Johnson. We have a little bit of time left if there are other commissioners who would like to address the issue. Commissioner Ross.
Yes, thank you, Commissioner Andreas. I want to start by again thanking Bob and Christina and Kate both for their tremendous leadership. Pleasure to serve on such a distinguished commission. It doesn't matter; it's critically important to our Republican form of government. And I want to thank Commissioner Pildes for presenting the part of this part of the report, and for the hard work that I know that he has put into the work of this commission. I think I want to kind of just engage the point that's been made about sort of this question about the politics of it all, because I think it's important to reinforce points that are made by Commissioner Johnson and Commissioner Gertner. I want to start by associating myself with Commissioner Gertner's point that judges have philosophies. Scholars, lawyers, members of the public label these philosophies conservative and liberal. But however you want to label them, these different philosophies often lead to different views and decisions in cases involving democracy, individual rights, federalism, separation of powers, and other critically important matters to our republic and to the American people. If judges did not have conservative or liberal philosophies, I'm not sure there would be reasons for presidents and senators to care so intensely, or as intensely as they do, about who gets nominated onto courts, and particularly the Supreme Court. Certainly, presidents and senators should care about putting persons on the court who are impartial, knowledgeable, and have the right temperament to serve as judges. But I think we would be blinking reality if we thought it was merely the desire to secure impartial and capable judges that drove the tremendous amount of presidential attention devoted to Supreme Court nominees and the extraordinary intensity of confirmation battles. Instead, what seems absolutely clear to me is that presidents nominate and senators seek to block or confirm judges on the basis of their judicial philosophies. And we are now in a unique moment in which the turnover of judges might be losing the randomness that I think is critical to our process, as judicial appointments increasingly become the target of strategic manipulation. Many think it is justices who are strategically retiring, which may or may not be true. But what seems clear is that the Senate, through its decision regarding Judge Garland and Justice Coney Barrett, have opened the door to strategic manipulation of Supreme Court turnover processes in the future that needs to be addressed now. If the process for nominating and confirming judges loses its randomness, then there is a good chance that we will run into the problem that Commissioner Gertner described, the problem of an entrenched judicial philosophy on the Supreme Court. And I fear that the combination of strategic manipulation of judicial turnover and an entrenched judicial philosophy on the court poses a greater threat to the legitimacy and stature of the court that Commissioner Griffith is so rightly concerned about than reform of the turnover process through term limits or the size of the court through expansion. And so I think that moment it needs to be critically underlined and emphasized as the moment that we're facing. And it's why I think that we need to at least acknowledge that judicial philosophies and the differences between them ultimately matter. Thanks.
Thank you, Commissioner Boddy.
Yes, hi. Like others, I want to take a point of personal privilege first to acknowledge the extremely hard work of our colleagues in putting together these respective chapters. Just extraordinarily grateful for them, as well as for the direction and guidance of our co-chairs and our rapporteur. So just for the record, wanted to express that while I have the chance. I also want to preface what I'm about to say by saying that I recognize the importance of identifying the pros and cons of the reform proposals that have been floated. And so what I'm about to say is not intended to cast doubt on the usefulness of that exercise. I think if anything, it invites those of us who hold particular perspectives to voice them with greater clarity and precision. And I also, finally, this is my last prefatory comment, I do think that, a drawback, as others have recognized with how the commission is structured, is that it makes it very difficult for us to engage in a real-time back and forth conversation about proposals, which might alleviate the need to include sort of the panoply of responses, pros and cons in the drafts. And that structure, of course, is not the fault of anyone on the commission, but is a function of the federal statute that we're operating under. Okay, so those are the prefatory comments. My real comment is that I think, given all that or in view of all of that I've just said, I think we have to be very careful about the articulation of the pros and cons and to take rigorous account of the other side's position. And the example that I will point to is the language on page 5, the second paragraph under objections to term limits. And the draft reads, according to opponents, it is decidedly not the role of a judge to decide cases according to the judge's estimation of the temper of the times, except in the rare instance where the law requires consideration of contemporary mores in a particular context. Rather, say the opponents, it is the role of a judge to apply and develop the law using the tools of judging emblematic of the centuries-old common law tradition, et cetera. Assuming that this description accurately reflects the opponent's critique, I don't believe that this critique takes account of what the proponents of term limits are actually saying. So, for example, the bottom of page 2 in the draft states that proponents of term limits would, quote, make individual members of the judiciary independent at any given point in time, but the composition of the judiciary as a whole responsive over time to the people, as expressed through its electoral decisions about who occupies the presidency and the Senate. So I read this to say that proponents are not urging individual judges to evaluate the views of the body politic in making decisions. Rather, proponents of term limits are making the point that the composition of the judiciary as a body over time should take account of electoral outcomes as reflected in the roles specifically afforded in the Constitution to the president to nominate justices and the Senate to give advice and consent. I'm concerned that leaving this language in the report would give what some have described as inattentive readers the chance to cherry pick language from the report that does not fairly reflect the views of the proponents. And I would recommend that it be removed. Thank you.
Thank you. Commissioner Morrison.
I just about lowered my hand because I think the point I was about to make is very close to the one just made. I don't know if I agree with the suggestion to remove that particular language that Commissioner Boddy has just identified, but I think that the point she was making about the point of view of the proponents is, I think, what Commissioner Johnson was earlier saying as well, that one need not fall into the position of making the claim that Commissioner Griffith is concerned with, namely the suggestion that judges are nothing more than politicians in robes. One need not end up there in order to observe the obvious, which is judicial philosophies exist, ideologies exist, substantive value sets exist. And the question then is about how best to articulate that understanding in a way that's not misunderstood to suggest merely that judges are partisans or politicians in robes. My reading of the chapter is that it is that it pulls this off quite well. I think it's a really admirable job that's been done in this draft. But it may be that the language that Commissioner Boddy has just identified should be reconsidered. But I think the goal here is clear, and it's to ensure that the argument on behalf of term limits isn't misunderstood as suggesting that a kind of regular vacancy process would achieve some goal of politicizing the judiciary in that way. A responsiveness to democracy need not be converted into or understood merely as judges operating as politicians. As I say, I don't think the draft, on my reading, misportrays the argument in favor of term limits in that way, but perhaps there's more that can be done to make the distinction between partisanship and ideology even clearer. And the fact that responsiveness to democracy in some way is not necessarily reducible simply to partisanship.
Thank you. Is there anyone else who would like to speak before we move on to the next set of materials? Commissioner Griffith.
Yeah, I just want to say I agree with what Commissioner Morrison just said. That there's clearly a distinction between party affiliation and judicial philosophy. And we need to recognize that and acknowledge that. I don't think that's a bug of the system. I think it's a feature of it. The concerns that I've had and expressed are those views that suggest that what's going on now is actually a partisan issue, trying to exalt one political party's platform over another. And I think we all agree that that's inappropriate. That's the distinction I'm trying to make. Not that judges don't have political judicial philosophies. I do, and I think those are fair game to debate and to vote against someone if you think that their view of the role of a judge is consistent with the Constitution requires.
Thank you, Commissioner Griffith. Okay, with that, I will turn things back over to Co-Chair Rodriguez, and we will turn to the next chapter.
So in this next session, we'll be talking about the draft chapter 4, and we will discuss materials that present an analysis of proposals that would in some way reduce the power of the court in relation to the other branches of government. And for an overview of chapter 4, I will turn to Commissioner Caroline Frederickson.
Hi, and thank you. Before I get into the chapter, I do want to thank the co-chairs so from the bottom of my heart for all their hard work and their collegiality, as well as the members of my working group who were really just a pleasure to work with. And so our chapter, as Co-Chair Rodriguez had mentioned, is somewhat different from the earlier discussions because what we've talked about, what we're analyzing, is the proposals that don't shape the court in terms of size or personnel, but actually try and address the power of the court by reducing it or the power of the judicial branch as a whole. In this chapter, we look at the proposals that would reduce the power of the court, and in part as a way of shifting power to resolve the big questions of the day, social, political, and cultural, away from the court and to the political branches. Those who support these ideas argue that the Supreme Court has played too large a role, has too much power in our system of constitutional governance because it's been interfering with or taking away control from the other branches that should actually resolve those questions. Under this view, the court has emerged as an obstacle to the realization of important social goals and undermined the ability of Congress and other political actors to protect rights. Without attempting to address all the mechanisms to reduce the court's power, this chapter looks specifically at jurisdiction stripping, supermajority voting requirements to invalidate congressional or other government action, as well as the other rules that would require greater deference to the political branches, And lastly, to legislative overrides by Congress of the Supreme Court or other courts' decisions. And in looking at these proposals, we analyze how they might affect the court or court's role in relation to the other branches of government, potential benefits and costs of the proposals, and whether they could be achieved without a constitutional amendment. So these proposals to disempower the court generally rest on two related assumptions. First, a determination that a statute violates the Constitution requires exercising judgment about what the Constitution means. And that is something that, as we all know, many people can disagree about, and the justices themselves disagree about. And therefore, and in addition, that principles of democracy require that Congress and the executive branch have opportunities to check the decisions of an unelected judiciary and to advance their own views of the constitutionality of legislation and executive action. For some, this view rests on the belief that the court has stepped into political battles that are resolved by elected officials, such as abortion or voting rights. But in addition, some argue that Supreme Court justices are nearly always drawn from the elite and so don't represent the population as a whole. Those who would check the court's power also note that because of what is called judicial supremacy, the view that the court has held that it has the last word on constitutional interpretation and that its decisions bind not only the parties in a particular case, but also future action by the president, Congress, and the states, that the court's decisions are difficult to challenge, and especially because our Constitution is notoriously difficult to amend. And with the justices' life tenure, they can become, it is argued, increasingly unrepresentative over time. So in these proposals, some of them specifically target the Supreme Court, but others would also apply to lower courts. Some would insulate broad categories of legislation from judicial review. Others would limit judicial power only with respect to specifically identified issues. So in this chapter, we consider the extent to which such proposals would affect the Supreme Court's role or that of the judiciary as a whole in relation to other branches of government to resolve important questions, as well as the counter arguments. Those who criticize these proposals worry that such reforms might undermine protections for individual rights, and in particular minority rights, or that because of the possibility of competing interpretations of the Constitution, the law could become less settled or reflect less well-reasoned constitutional decision-making. Critics also emphasize that these reforms could undermine rule of law by eliminating the court's role in ensuring accountability of government officials. And of course, there are some who simply contest the idea that the courts are operating in a way that is anti-democratic. So in this chapter, we engage in a discussion that is really much more analytical and don't purport to resolve fundamental questions of democratic and political theory that any substantial disempowering of the courts would raise. Instead, we analyze the extent to which the various proposals to disempower the courts reach the goals proponents hope to achieve and identify some of the potential costs, including from the perspective of those who emphasize the importance of the courts in protecting individual rights, federalism, or other constitutional values and structures. And finally, we discuss the constitutional issues they pose and evaluate whether the proposals could be achieved without constitutional amendment. So I do want to thank everybody, in closing, other members of the commission for the very helpful comments that we had. We did make some changes to the chapter that were reflective of those comments in order to tighten language and clarify issues where there was some ambiguity about how we had stated it in the initial draft. So I do want to thank you, and once again, thank the co-chairs for their fearless leadership of all of us. Thank you.
Thank you, Commissioner Frederickson. So we did have one person who expressed an interest in commenting on these materials. So I will start with her and then open the floor to others who might have something to say. Commissioner Grove.
Thank you, Co-Chair Rodriguez. So thank you so much to Commissioner Frederickson for that great summary. And I just want to commend those who worked on this chapter. I think they've done a great job. And I think throughout this public meeting, we've been recognizing just how much work has gone into this. And I think we have all benefited from the fact that some segment of our commission has worked very, very closely on a part of the draft. And I will say I am inclined to be somewhat deferential to the decisions made by people in particular groups, because they have worked so closely on a particular issue and spent so much time and care on it. And here it's just been fantastic work on Chapter 4. So there's a mountain of literature on Congress's power over federal jurisdiction. And this chapter manages to go through it pretty deftly and carefully and cover a lot of ground in a pretty short number of pages. I also appreciate how Chapter 4 picks up where Chapter 1 left off in talking about some of the post-reapportionment attacks on the Supreme Court and the lower federal courts, and shows how there's been a lot of late 20th century and early 21st century debate over court reform, over national security, desegregation remedies, school prayer, abortion, marriage equality. And I think that's a nice context for our report overall. And I thought the analysis of supermajority requirements was very nuanced. And I appreciate the changes to the discussion of legislative overrides. So overall, I think it's a fantastic chapter. And I do so appreciate the work that went into it.
Thank you, Commissioner Grove. Is there anyone else who would like to comment on Chapter 4? Commissioner Andreas.
Thank you. I wanted to also echo Commissioner Frederickson in thanking those who made really constructive criticisms and comments at the last meeting, which I think ultimately have led to a clearer and more useful chapter. And for many people, I think this chapter is not the most exciting. It might even be described as dull or overly technical, but I think it really deals with a topic that is extraordinarily important. And it's worth underscoring that we really received quite a bit of testimony from a number of experts and organizations across the political spectrum expressing concern that the Supreme Court has exercised too much power over decisions that really ought to be made democratically, or put differently, that the court has at times been insufficiently deferential to the judgments of Congress, and as a result inappropriately struck down legislation. But at the last meeting, several people made really constructive comments about how and where this chapter needed further clarification and elaboration. And I think those changes strengthened the draft. And I just wanted to highlight two ways in which the two additional changes that have been mentioned, but I think are worth highlighting. And one is that the draft provides a lot more detail on legislative overrides and how they actually work. For example, in Canada. And the draft is also clearer that most reformers have assumed and seem to agree that a formal system of legislative overrides would require in the United States a constitutional amendment. But the revisions also strengthen the draft in that they highlight the powers that Congress already has, or that many scholars think Congress already has, to engage in the important task of constitutional interpretation and enforcement, even without amendment or even without statutory reform. And then finally, to note that some commissioners at the last meeting raised, additional technical points that I think are really important, and that the draft actually still doesn't grapple with, because adopting any of these forms would be very complicated and difficult. And so the draft, I think, still leaves for future elaboration and discussion many issues in the interest of remaining at least somewhat readable. So again, thanks to those who read so closely and made suggestions.
Any other comments from commissioners on this chapter? I'll make one observation about the chapter, which is, as Commissioner Frederickson mentioned at the outset, it doesn't purport to take a position on the questions of democratic theory that are implicated. Those are questions that are perennial and longstanding in debates in constitutional theory and in political theory about the proper role of the court, especially a court that consists of life tenured judges and justices in our constitutional system. But what I do think that it does in a way that is to its credit, and I hope will be a long-lasting contribution of the report, is think through how various forms of disempowerment might actually work and what the complexities associated with those reform proposals might be, as Commissioner Andreas suggested. And it does the work that we were charged to do, which is to analyze whether various ways of reducing the court's power within the system actually meet the objectives of the proponents of those reform proposals. And in doing that, especially with respect to its last part, I think it opens up new conversation about how to think about ways to reshape the court's role in our system of democratic governance. And so it adds, I think, a depth to a longstanding debate that is sorely needed, and in that sense makes a significant contribution. So I think the people who labored over this intensely for so long. And if there's nothing else on chapter 4, we will move on to chapter 5, and I'll hand this back over to Co-Chair Bauer.
Thank you very much, Commissioner Rodriguez. We're going to turn now to the materials that present analysis and competing views on proposals relating to the Supreme Court's practices and procedures. We'll follow the same model that we have up to this point. Commissioner Wong will provide an overview, and I'll recognize him first, and thereafter there will be commissioners who have comments to offer, and we'll open it up to anybody else who would like to speak to the issues. But first, let me recognize Commissioner Wong.
Thank you, Commissioner Bauer. I mean, really, thank you. And thanks to Co-Chair Rodriguez, and thanks to Commissioner Andreas as well. So as we all know, public discussion about the Supreme Court has highlighted not only the structural proposals analyzed in these previous chapters, but also the court's internal procedures and practices. The commission heard from expert witnesses on these topics over the course of the 2 sets of hearings this past summer. We've also examined commentary from lawyers, scholars, judges, and several of the justices in their recent opinions and public statements, as well as from hearings separately held by the House and the Senate this past year. The draft of Chapter 5 draws on this commentary, and gratefully, it also draws on the wide-ranging input of you, our fellow commissioners, during our last round of deliberations in October. The chapter draft focuses on 3 sets of issues of especially high salience in public debates and commentary. First, emergency orders. Second, judicial ethics. Third, courtroom transparency. In the first category, emergency orders, the draft covers current debates about the court's use of emergency rulings, including high-profile, high-impact orders that allow or don't allow a new law to take effect, while legal challenges about that law continue forward in the courts. Public debate has often focused on how emergency rulings differ from the way the court usually decides cases. For example, how emergency rulings are informed by less briefing, don't involve oral arguments by the lawyers, and often do not give much explanation of the court's reasoning. While acknowledging that emergency procedures are necessary, commentators, including commission witnesses, have raised concerns about the court's emergency rulings in recent years, and they've suggested ways to address these concerns. The first section of this chapter addresses these concerns and proposals, as well as counterarguments. The second section covers judicial ethics. The draft recognizes that there has been much public discussion, including bills in Congress, about the fact that, unlike other federal judges, the justices of the Supreme Court are not formally bound by a code of conduct, although they may consult the code that applies to other federal judges. Also, unlike other federal judges, the justices are not subject to the federal statute that governs judicial discipline. The draft chapter examines commentary and proposals about these issues, as well as about recusals of the justices. The third section on courtroom transparency is about how to help the public observe the Supreme Court's proceedings in real time through live audio streaming, or maybe someday even video. In addition to these sections in the chapter, a part of the appendix to the report will highlight witness testimony about advocacy and informational inputs to the court, topics previously addressed in the discussion materials. So now a hearty word of thanks is in order for everyone's input in our last round of full commission deliberations about that original set of discussion materials. Having taken into account your many insightful suggestions, the draft chapter is now more tightly structured, with a sharper focus on those issues which have been highly salient in current debates and are of great public concern. It's also incorporated your suggestions about coverage, about matters of voice and style, terminology, and about how to understand the current debates. And like the rest of the report, it sought to find points of equilibrium among competing views in the commentary and among commissioners. Finally, of course, it's been updated to reflect the latest developments, including how the court's practices have continued to evolve and how public debates have been evolving along with it. So thank you again. A special thanks to our friends on Working Group 5. You know who you are.
Thank you very much, Commissioner Wong. I'd like now to recognize commissioners who'd like to speak to any of the issues raised and discussed, analyzed in Chapter 5, and I'll begin with Commissioner Bode.
Thank you. And I want to again voice my real appreciation to the people who worked in this chapter. I think it's really dramatically improved from the version of the chapter we saw at the last meeting. And I know that took a lot to get it there, and I'm really glad that happened. And mostly I just wanted to say how much I like the chapter compared to where it was. I will throw out one last concern I have is with the section on courtroom transparency, which I worry is a little too one-sided in its assumption that transparency is always good for the functioning of government organizations, and that therefore the court should be sort of encouraged to move towards more and more transparency. I think the experience from other branches of government, the debates about the sort of effect on increased television on Congress and other things, should at least make us be less certain about how much transparency and how much real time we really ought to have. I mean, I think we note the sort of experiments the court is doing, but I think we probably ought to leave it to the court without more information to sort of decide whether this should be encouraged or not encouraged. And they probably know more than we do about the effects that all the various transparency and so on has on them. I mean, I think we ourselves, of course, have been proceeding under a complicated set of rules about transparency, which have created, of course, great public benefits, but sometimes great logistical difficulties. And so I just sort of suggest we ought to be a little more cautious about assuming that there's a one-way march towards more transparency being good. Thanks.
Thank you very much, Commissioner Bode. Any additional comments addressed to Chapter 5? If that's the case, we'd like, and please feel free to interrupt with a raised hand, but I will move now, unless otherwise interrupted, with someone who does want to make a comment, to some closing remarks at the end of this session. Very briefly, first, I speak. Oh, Commissioner Morrison.
I won't take long. Thank you. I just did at a number of points throughout today. Various of us on the commission have thanked you, Co-Chair Bauer, and you, Co-Chair Rodriguez, and you, Rapporteur Andreas. But I thought maybe it would be just appropriate, without purporting to speak on behalf of everyone, to say that one more time. For the public that is joining us today, there's just no way that you could appreciate the awesome task that these folks have undertaken in guiding us through this process. And I know that all of us on the commission, I think I can speak for all in saying how appreciative we are. And I will, on my own behalf, say that I'm just stunned by the leadership that you've displayed here, each of you. And so we are deeply, deeply grateful for it. Thank you.
Well, I mean, thank you very much for that, Commissioner Morrison. I will just say for my own part, and I doubt that Commissioner Rodriguez, Commissioner Andreas disagree, it all matters who you're trying to support here. And our view was that we were supporting an extraordinary collection of individuals that the president asked to serve on this commission. And that certainly made the task for us far, far easier. It was always stimulating. It has continued, and I hope it will continue to be stimulating until we reach a conclusion. But for our part, we think the thanks, I certainly would express it this way, run the other direction to a really remarkable group who, despite their disagreements, are ever thoughtful about how to meet this charge at a time when this sort of reasoned discussion is so terribly important. And I'll pause there, by the way, in case there's something that Commissioner Rodriguez or Commissioner Andreas would like to add to that.
I would only add that it's been almost entirely a pleasure, and we still have work to do. And I have learned humility from this experience about the views that I hold and my ability to persuade others. But that experience of hearing the diversity of perspectives has been the one that I will take away, especially at this moment in our political life.
Thank you, Commissioner Rodriguez. Commissioner Fallon.
Yes, I just wanted to echo what Commissioner Morrison and others have said and add to that a thanks to the staff. Some of us have participated in this process under the handicap of severe difficulties dealing with the technology that has been necessary to make this commission work. And the staff in dealing with that issue, among others, really could not have been better.
Well, thank you, Commissioner Fallon. And you anticipated in my, before I responded to Commissioner Morrison in my closing remarks, one of the things that I was going to say, apart from thanking the commissioners and thanking members of the public who have joined these conversations, is to tell you how much and to inform the public how much we have benefited from the extraordinary support from the GSA team, Dana Fowler, Patrick McConnell, and others who have been indispensable on the technology issues, on a whole host of complicated issues that have to be resolved logistically for this to occur. They have not only performed extremely well, but they have maintained what I would have to say an astonishing sense of humor and patience that is an inspiration to us all. So we're very, very grateful to them and to all the members of their team. Let me also say again that we will reconvene on December 7th to consider a draft final report and to vote on whether to submit it to the president. We welcome, as Commissioner Rodriguez said earlier, comments from the public, and we'll be receiving them throughout the life of the commission. We'll continue to accept those comments until December 15th. However, we want to stress that the comments that are most helpful to us are ones that would be submitted by 5 p.m. on December 3rd, 4 days before the final public meeting. Those comments, as you know, can be submitted to regulations.gov, and the comments received to date are also available for the public to review on that site at that address. To find the comments, you can go to the Commission's website where the links are posted, or you can go directly to regulations.gov and search for PC SCOTUS. So with many thanks to my fellow commissioners, to Co-Chair Rodriguez, Rapporteur Andrius, and to the public for joining. That concludes our session today. And thank you very, very much for participating. We hope to see you again in December. Good evening and have a good holiday weekend.